Hi, everybody.
Hey.
How's it going? Happy Monday. We
Uh,
are alive. We're here.
Barely.
We are here in body, if not in spirit.
Mostly in
So,
spirit.
maybe not even that some days. Okay, I'm going to give it a couple minutes and let people kind of join, but we're going to go over the Jed Wallace case because I have done some videos on it. I've kind of taken down a lot of my old videos because I don't think I did a good job explaining things. And now I feel like a year out, I'm a little bit better at it.
I think you do a great job explaining things.
I feel like going back, and this.
I understood everything.
You're an attorney. But that's the thing. Like, I think because you just kind of did this too. Like, you go back at your old content and you're like, oh, yeah, I don't know if I would have done that same way,
Yeah, I really do know. I'm going through all my old content right now and just being like, yeah, on the internet.
See, I'm not like embarrassed about it. I'm just like, I don't feel like I'm comprehensible. But yeah, I mean, now hopefully we'll get there,
See, other Sarah says you're extremely good at explaining, girl.
Oh, thank you.
Hype her up, Sarah. And also, hi back to Australia, Sinking Universe 123, which feels like an apt description of the world today.
Sinking Universe. Yes. Kat, for some reason, I feel like I wanted to crochet. It's the yarn background. I'm very proud now because now there's definitely no like AI. I didn't know where I got that other background. So now I'm like, I can say I made my own background.
Someday I'll make you the wind chimes and you can actually put those up as your background.
And just, have them in the background. So let's see. Yeah. So I do want to go over the Wallace lawsuit, and I'll need to set the stage for the 47.1 thing. And so I don't know how much time we're going to have. So I'm going to go live on Wednesday and just talk about 47.1 because I have a lot of DMs. Speaking of being good at explaining things, I have a lot of DMs from people that are like, hi, I have seen all of the lawyers talk about 47.1 and I still don't get it. And I'm like, okay.
My delusional, half-baked video today probably won't help. Like, y'all, I am so tired. Couldn't tell you the last time I slept through the night.
I mean, I think some of it is just like there's just certain assumptions that lawyers make about like federal court and state court and types of motions and how case law and precedent work that like all of us are like, So I want to go through the 47.1 motion that Babcock wrote. I want to go through the case law and kind of explain the difference between federal court and state court and like different types of fee shifting motions. So, for people that are like, I want to spend my Wednesday night listening to knowing about fee shifting motions in federal court. Fair enough. So, but first thing, so I do want to go through Wallace's lawsuit to kind of explain what he is suing over. Okay. So if you're here, I'm going to assume that you're fairly familiar with the Lively Wayfair case as far as the claims. If you're not, God help you, because at this point,
Blake Lively sued her production company and various individual defendants for a whole bunch of nonsense.
Yes, and because she just recently settled for $0 out of $300 million, I think we can all agree it's a resounding victory for Lively. I think she is. I think she is delighted. I think everybody wants to spend $60 million to potentially win $300 million and then settle for zero. I think, yeah.
I love spending money that I'm not going to get back. It's my favorite thing ever.
Yes. And then also harming your career in the process, which is just really the even better, right? That's the sweetener is
Katie.
Knowing. Hey, Katie.
Honestly, at this point, my career can stick it.
Well, if you're going to ruin your career, hopefully you do it in a slightly better way that doesn't cost you $60 million.
Yeah. I mean, I could just walk out for free, but I'm not Blake Lively, we all like to do things differently.
Yes.
Don't mess with Texas. Exactly, Katie. Exactly.
Yes. Wait, what Blake Lively lawsuit? She sued someone? She is my absolute favorite person in the whole world. On the small chance you're not kidding, Blake Lively didn't do anything. Don't ever Google her again. Just continue to watch Gossip Girl or whatever things, and just move on with your life, and make sure you never type her name into Google.
Ever.
Like ever. Yeah.
Well, I mean, to be fair, her smear campaign was really successful, so you may just get like People magazine headlines.
That's fair. Yes. So, hi, Katie. So, she's a shy girl. That's important to know. Shy girl. She is shy in the way that I'm a fitness buff, which is to say that I haven't left my apartment since Saturday. So, all right. So so here's how we're going to start trying to explain the Wallace lawsuit. So the first thing that I want to do is explain the dismissal in the Lively and Wayfair thing, because Wallace is suing for defamation the way that Wayfair did, but he's doing it for a different reason and with a different fact pattern. It's not just the Texas thing. It's also just that things are different in the cases.
I think he has a pretty decent case.
I think the case law that I found is like insanely similar. And they allowed a defamation claim. Yeah, for fact ways. And I'm going to pull up some case law that I found and I think he has a much better shot than they do. All right. So I'm just pulling up. This is from the dismissal of Wayfair's defamation case in New York against Lively. So this is something that Wallace was not a party to, but I want to kind of go into why did Wayfair's defamation case against Lively get dismissed? So what Lyman said, and he's basing this off of California law, right? So you can see here where it says California Civil Code on this top paragraph. He is using California law to evaluate this because Wayfair sued under California law because they are based in California and the harm was disproportionately felt in California. So what he said is, when you're, so it's kind of this lawsuit here where it starts with assuming the lawsuit is actually filed. Assuming the lawsuit is actually filed, the statements will, or actually I should read this quote above. The test is satisfied by demand letters and like communications between litigants or their attorneys, which are directed towards settlement of a pending or anticipated lawsuit. So we're talking about pre-litigation type filings. And this is where he puts the CRD complaint, else kind of when he's explaining this. So he says, assuming the lawsuit is actually filed, and we know that it was, we know that Lively did file her CRD, the same type of lawsuit that was her CRD complaint. The statements will also be privileged when published by the media outlet. Applying the fair report privilege, and this is, so I think this was the New York fair report. He kind of did both, kind of split it, but we'll see how that goes. Applying the fair report privilege in this situation protects the bridge between these two privileges. So what you've got is Blake has a CRD complaint. She provides that CRD complaint to the New York Times. And then at the same time that she files the CRD complaint, the New York Times publishes the article. So the question is her pre-litigation communication to the New York Times also covered? And what Lyman says is the case law in California says that it is. Because basically it's you don't have to wait for the press to respond to the lawsuit or to the litigation. You can go ahead and kind of work with the press beforehand, as long as you do eventually file the litigation.
Right. As long as the thing they're covering eventually ends up in court.
Exactly. Right. Because if you think about it, it's kind of the same either way. It doesn't really matter if the New York Times reads the lawsuit and then publishes an article a day or two later versus Lively giving them the stuff ahead of time to write the article. If anything, you could argue that would actually make it more likely that the article doesn't get anything wrong because they've had a little bit more time to look at it and they're not rushing to get something out. So what he says here is so long as litigation was actually contemplated seriously and in good faith, the fair report privilege applies to a party who communicates a complaint to the press before that complaint is publicly filed. So this has to do with Lively's communication with the New York Times because eventually she actually did the lawsuit. There we go. And what he says is there's no basis to infer anything other than the litigation was actually contemplated seriously and in good faith. In the first place, Lively commenced litigation. She filed the CRD complaint, and then he goes into the history of the case. So that's why Wayfair's defamation claim got dismissed. He said this is privileged, and this is why it's privileged. Okay, so let's go to Wallace. So this is the Texas definition of litigation privilege. Litigation privilege applies to pre-litigation communications when litigation is contemplated in good faith and under serious consideration. So the question is, did that happen here? So here's my handy dandy flowchart that I actually made all on my own. Okay, if I can get this all on one page. Okay.
And keep in mind, we're applying Texas's litigation privilege to Jed because Jed
he is in Texas.
It has been in Texas.
Right. So Jed is filing a defamation lawsuit in Texas. So before I get into the actual lawsuit, I want to explain how litigation privilege works in Texas because it's different. So we're starting here. Was a statement made as part of a lawsuit or a prejudicial proceeding necessary for a lawsuit? And I think Lively's going to say it was, right? So we're going to go yes. And then if yes, was the statement limited to that lawsuit or prejudicial proceeding? The answer is no, because she gave it to the press here. So you can see this down arrow where it says no. And then the answer here is it's not privileged. So the distinction, the quote here is, the distinction the privilege draws between in-court and out-of-court statements would be a dead letter if an out-of-court statement thought by the lawyer to advance his client's interests enjoyed the shield of attorney immunity. So basically, where in California, Lively going to the press is protected because it doesn't, their view is it doesn't matter. In Texas, they're like, no, it does matter. You have to wait and the press has to get it themselves. So if the media finds the litigation on their own and writes an article about it, that's fine. But if you give it to the press ahead of litigation, it's not fine. That's the difference in Texas.
And Texas probably looked at the California law and they were like, we hate California.
Exactly.
I'm kidding.
Right. No, I mean, I don't actually think you're far off, but I do kind of see the argument, right? Or I think it might be, I would imagine more states are probably like Texas, but then states where the media, it has a more prevalent presence is California and Texas. Like the New York Times is the basis of most of the First Amendment law in the United States.
Right.
So New York has really good press protections that we don't have in other states. So, okay. So let's look at the Wallace Lively case. So on December 20th, 2024, Lively files a CRD complaint. It was filed by Ezra Hudson, and she got a right to sue letter from the state. Now, this is a necessary step for her to go to court. So before she files a lawsuit, she has to do this. So we can see here, Jed Wallace and Street Relations are highlighted, and they are co-respondents. So she's saying she was harassed, she experienced retaliation, and then she also puts in here aiding and abetting harassment and retaliation. I'm highlighting that because that's eventually what she said that Wallace did. So this is where he was put on the employment complaint. Then the New York Times article comes out. And what happens in the New York Times article, this is the part that I don't think the media has caught on to. I don't think the content creators have really thought too deeply about this because it doesn't really matter unless you're talking about Jed. So New York Times published this document, which is, they call it a precursor lawsuit. This document, as it is here, was never filed in any court. This looks like a lawsuit, and it is very similar superficially to the lawsuit that she did file. But the big thing here is Jed Wallace and Street Relations are on this document. But this document, go ahead.
And they linked to this, right?
They
read this complaint.
Yes.
They linked to this. This is not filed.
This is not filed in any court.
So this was some draft that Blake's lawyers presumably sent to the New York Times saying, this is what we're going to file.
Yeah.
And then at some point, this draft
is what's linked.
Gets thrown into the drafts and doesn't get filed.
And in fact, the New York Times said, read the complaint here and linked to this. Which this looks like a lawsuit, but this is not a lawsuit. It's on pleading paper and whatever. And you can see here where I've highlighted Jed Wallace and Street Relations are on this document. So as an example, Elle Magazine runs this following article about Blake Lively's lawsuit against Justin Baldoni and says, in this article, they say, who is Blake Lively's lawsuit against? And you can see here, they have at the bottom listed Jed Wallace and Street Relations.
Which is the last time the media talked about any of the other defendants. The rest of all time, they wanted everybody to believe Justin Baldoni was the only defendant. Person. Don't look at anybody else.
Right. But you have this where it says Jed Wallace and Street Relations. So Elle Magazine saw the New York Times complaint. They believed that there was a lawsuit that Blake Lively had filed against Jed Wallace. And they reported on it and said she was suing Jed Wallace and Street Relations.
Except she wasn't.
And then this is the document that was eventually filed. This is document number 1 out of 1,400 that was filed on the docket. And notice what we don't have here, which is Jed Wallace's name or street relations name. So what he is suing for, I'm going to read what essentially this is the crux of his lawsuit. Wallace and Street were widely reported to be defendants in the formal lawsuit, although they were not, the confusion having been sown by the precursor. As Lively later admitted, she knew of no facts to support the allegations against Wallace or Street. Indeed, having been the one harassed, she knew the exact opposite. Neither Wallace nor Street had anything to do with the alleged harassment, retaliation, failure to investigate, or aiding and abetting of the alleged harassment or alleged retaliation. Neither could they have breached a contract with Lively because no contract exists, and they were not involved in any of the events depicted in the precursor where they were named as defendants, or the formal lawsuit where they were not named, which could give rise to a duty towards defendant for negligence or any other tortious conduct, false light, intentional infliction of emotional distress, or interference with prospective economic advantage. So what they're saying is, you told the media that you were suing us, and then you didn't sue us. And that's defamatory. And this document is not anything. That's the argument. This document, this does not fall under any sort of privilege because this is not the document that got filed in court. So that's the crux of Wallace's argument. And at the time that he filed the defamation lawsuit, there was no active litigation. It was only after he filed the defamation claim that she added him to the lawsuit. A little bit too late there.
Whoops. Ooh, Whoops. Can I amend and add him? I forgot to do that. Super
Whoopsies.
Sorry, Kay. Please don't sue me.
Yeah, too late. So that is what he is suing for. So that is the crux of his lawsuit, right? He said, you accused me of all of these things. You put this on pleading paper. You made it look like a lawsuit, and then you didn't actually file it in a court. So you don't get to say, as we go up here, applies to pre-litigation communications when litigation is contemplated in good faith and under serious consideration. So there you go. So here's the case law that I want to point out. This is in the Supreme Court of Texas. This is from 2021. It's Landry's versus the Animal Legal Defense Fund. I'll try to go over this quickly, but basically, the Court of Appeals held that an attorney's pre-suit efforts to publicize allegedly defamatory statements are shielded from liability by the judicial proceedings privilege or attorney immunity. For the reasons explained below, we disagree. So they overturned a defamation claim that was dismissed on the basis of litigation privilege.
Because it was made before the lawsuit had been filed. Correct.
So the fact pattern is Landry's, which is like it's like a hospitality company in Texas. They own the Houston Aquarium, and there are some tigers that live at the aquarium. And there was some sort of journalist. She went to go visit them. Then she contacted the Animal Legal Defense Fund because she said the tigers were being kept in poor conditions.
The ultimate orange cat, by the way, is a tiger. You guys know anything about orange cats? They're ornery.
Don't they have like emotional? Are they the ones that have emotional support animals, or is that cheetahs? If you guys know, put it in the chat.
We love orange cats.
There's some animal that has like emotional support golden retrievers in zoos.
Oh, I think it's cheetahs.
I think okay. So they so the Animal Legal Defense Fund, it's an animal rights organization that's founded by attorneys. They sent Landry's a 60-day notice, a notice letter, and they said, we're going to be suing you, right? They're saying your tiger facilities are in poor condition, etc. And then the same day, they posted a press release on its website talking about the notice letter and criticizing it, so republishing it. They also posted a link to the notice letter. And then they sent a copy of the press release and the notice letter to the Houston Chronicle and to a bunch of different television stations, who then reported on the pre-litigation notice letter. So then Landry's then sues for defamation, disparagement, tortious interference, abuse of process, trespass, and civil conspiracy. So they were looking for all these damages, and it got dismissed. And the reason what they said is they granted the motion to dismiss because they said this was a pre-litigation statement, and they did eventually file suit, so therefore it's covered. And the appeals court said, no, it didn't. They overturned this. They reversed the sanctions that they'd been granted and basically said, this is not how it works. So let me go back to the, okay, so here's the logic. So think about how this applies to Jed's case, right?
And just so we're all clear, the Fifth Circuit governs Texas, among other states, right? But the Fifth Circuit doesn't have any impact on New York. That would be the Second Circuit. Because it gets a little, you know, we have this crazy system where like the appeals go up, right? And so the circuits only control the districts that are below them, which aren't all districts. So
here's, if you guys want to know, if you're in the US and you want to know what district you're in, this is not the Hunger Games district, but you know, it's not that far off. So we're in the 10th. Well, I'm in the 10th. You're in the 9th. You're in that liberal hippie California district.
I love my 9th Circuit. And I love that it makes some people here very upset that we're in the 9th Circuit. It makes it even better.
I do feel like spiritually you belong in the 10th Circuit, and I don't mean that as an insult.
Yeah. I mean, you would think all four corner states would be together.
Yeah.
Right? Because Utah, Colorado, New Mexico, and Arizona have like common land masses.
Yeah.
Like,
yeah.
Geologically, we are one, but
we are one thing.
Yeah.
We are spiritually, yeah. So if you're not American, you can see here where Arizona is in the bottom left. I don't have a way of like drawing attention to it, but where the number 10 is, around that Four Corners area, that's where you should visit if you come to the US. So, okay. Let's see. Okay. So think about this in terms of the, think about this in terms of Wallace's case. The judicial proceedings privilege is an absolute privilege that covers any statement made by the judge, jurors, counsels, parties, or witnesses, attaches to all aspects of the proceedings, right? So this is like covering your statements that you make in open court. So obviously you need people to be able to say whatever they want in a lawsuit. So that's why we have that. So what they're saying here is attorney immunity is an independent defense. It's not merely the lawyer's version of the judicial proceedings privilege, although there is an overlap. It is an affirmative defense protecting attorneys from liability to non-clients. So think of that like with the Brian Friedman stuff, right? The reason why his statements are not defamatory is because he doesn't have liability to Lively, right? He's saying things that are advocating on behalf of his client. And there's a line, but that is, you know. So when applying attorney immunity, we have stated that it is otherwise wrongful conduct by an attorney, is not actionable if it is part of the discharge of the lawyer's duties in representing his or her client, right? So again, similar to the Brian Friedman thing, you're advocating for your client. So attorneys are not protected from liability to non-clients for their actions when they do not qualify as the kind of conduct in which an attorney engages when discharging his duties to his client, right? So some conduct by attorneys, even if it occurred during a lawsuit, would be actionable because it does not involve the provision of legal services and would fall outside the scope of client representation. Attorney immunity would not protect a lawyer when his acts are entirely foreign to the duties of an attorney. So the question is, do statements to the media count, right? So they're saying Texas law, not super clear on this. Shocking. They don't have a lot of media protection. Hello.
Hey.
So I'm going over this Landry's case law. So basically they're just covering the litigation privilege as it applies in Texas, and kind of I'm comparing it to the Brian Friedman's thing and saying they are sometimes how do I put this? They protect attorney statements as long as they are related to actually doing the litigation, and they're not covering if it's something like publicity. Some courts have extended the privilege to attorneys who publicize their clients' defamatory allegations to the media, as long as the allegations arise from a judicial proceeding. So that's why the case got dismissed against Friedman, right? Again, his statements are privilege. Who is Jed Wallace? Oh, that reminds me. Jed, if you're watching, there's my Buy Me a Coffee link. You're welcome. Okay. So what they're saying is they're declining to extend litigation privilege that far, right? What they are saying is, as I'll go here, the statements at issue here were made prior to litigation We have previously applied the judicial proceedings privilege to pre-suit statements as well as statements made within a proceeding. The requirement that the statement must bear some relation to a proceeding cannot be stretched so far as to include publicity statements that merely address the same subject matter as the suit, but serve no purpose within the suit. The statement itself must bear some relation to a proceeding. It is not enough that the statement's subject matter bears such a relation. So we go back here.
That's interesting.
Where you've got this precursor. This was filed as part of the New York Times, and Wallace is on here. And then we go here to the actual lawsuit that was filed where he's not there. So they're not the same thing. That's what I think is going to matter here. So although, and they kind of go into this, although accurate public knowledge of what is happening in the court system is of great value, that value is protected by defenses available in defamation law. It does not exist to promote publicity or public awareness outside the courtroom. Its purpose is to facilitate open and vigorous litigation of matters inside the courtroom, right? So this is very different than what we've seen in New York, right? Which is basically, if the media organically gets this, that's one thing. But if you're giving it to them for the purposes of trying to publicize your own stuff, that's not gonna be enough. So
Texas hates the media.
They really do. They really hate the media so much, you guys. But, again, just think of how this is going to apply to Jed, and think of like how you now and like be honest, right? Because it's like you might be happy with this in this case. Do you think it should always be like that? Right? Because it's and
9 times out of 10, the media doesn't give a rip about two litigants going at each other. It's famous people, right? Which really does apply a lot more to New York and California. So it makes sense that the laws are different, but it's just so funny. Like, this is so very Texas. This is so Fifth Circuit. Carry on.
So what they say is, we agree with the Court of Appeals that have adopted similar reasoning. Okay, blah, blah, blah. The absolute privilege is lost if the holder of the privilege repeats a statement outside the protected context within which the statements originally were made. Republication of such statements outside the judicial context waives the privilege, right? So what they're saying is the notice letter itself is protected by the judicial proceedings privilege because it was necessary, right? And that's why I brought up her right to sue letter. She had to do the right to sue letter in order to go ahead in federal court. So I do think that the court is going to find that CRD complaint itself is protected and it can't be the basis of a lawsuit. But the delivery of the notice letter itself is not an issue. The dissemination of the letter to the media, along with a press release and the defendant's other republications of their allegations, are the source of the complaint. So the defendants lost the judicial proceedings privilege protections when they repeated the allegations for publicity purposes outside the protected context within where the statements were actually made. So that's it, right? The dissemination of the notice letter and the press release are not protected by judicial proceeding privilege. The privilege does not cover other publicity statements made apart from the letter, such as statements to the press, blog posts, or social media activity. So that's them reversing the decision. So let's go back, right, to this chart, right? So the statement here in the Lively case was made as part of a lawsuit, and then Britt hired me to do Fame Sarah. I hope you're getting paid. Lauren. I can put you in timeout.
I would never.
I don't think you'd pay for it. I think you'd ask her to do it for free.
This is payback because we send Lauren every single day the most ridiculous text threads. Like, poor Lauren has to put up with us all the time. So this is only fair.
I like how in our group chats, you're like my emotional support lawyer. So we're in all the same group chats. So she gets to see me reuse the same jokes. Because I'll make a joke and I'll be like, that was a good joke. I'm going to post that in like a couple different places.
It's great. And I laugh at all of them.
And then it's like, yeah, everybody independently thinks I'm funny. And I've already tested it on the test audience.
It's great. I actually would be really sad if you had text threads without me.
I really don't. I just like to send you 4 of the same thing. So basically, that's what we're coming back to. So she files a CRD complaint, and I do think if we're looking at this in light of the Landry case, this is probably going to be protected. But then we've got this. So the New York Times article. So I'm going to pull this up from the actual docket to show you guys So this is the precursor lawsuit, and this is what was published with the New York Times. There was a link to this, and actually, I think there's a picture. Maybe not. Or is it in the complaint? I don't think it's in the complaint. I like the font they use. It's kind of... So that's the CRD complaint. So where she's listing Wallace and street relations. Then we've got the precursor. Okay, so this was linked to in the New York Times article. And we've got Ezra and Michael Golub on here. And this is where you see Jed and street relations. And it is basically the same thing. It's very similar. It's got all the same stuff. But this was attached to the New York Times article. This exact thing was never filed. And then what was filed is from here, docket entry number 1, missing Wallace and street's name. So, yeah, that's the bulk of the lawsuit. And then if he goes to court, I don't know if he's a public figure. I think that'll be an interesting question. Is he a public figure for a limited purpose?
I don't think so. I don't think she gets into public figure. Now he is, but he is because of her.
I think there's
working with public figures, I don't think is enough. Like there has to be some sort of...
Yeah.
I just don't think she can pass that bar.
And there's an advantage if he does, because then he gets that malice argument in, and then you get discovery about malice.
Yeah.
So that subjects her to more invasive discovery. Let's to say the least. So yeah, I think this is the McSweeney case of this case, Landry case. So look for Landry's Inc. and versus Animal Legal Defense Fund. I think that's going to be... I just realized it's the first time in a long time neither of you are wearing green. We aren't.
And just so we're clear, Jed sues her in Texas. She moves to dismiss and says, I don't live in Texas. There is no Texas jurisdiction. And the court agrees and dismisses it. Mm-hmm. And now he has filed a notice of appeal. So we are waiting for him to file his appellate brief, which he has not done yet.
That is due tomorrow. So if you've seen this live at this point, you're already kind of caught up. So she got dismissed for jurisdiction the same way that he did in her case. So basically the courts are like, I don't know where the hell y'all need to sue each other, but figure it out.
Got dismissed for jurisdiction. She came back and asked for attorney's fees of $800,000.
Yes.
Ma'am. That's not, you guys, if your attorney charges you $800,000 for a motion to dismiss mostly on jurisdiction, you got played. Do not pay that. Contest that.
I mean, yeah. So I'm gonna put this in the so this is a link here. I don't know how to make it fancy, but if you go here to this link, this is the appellate docket. So this is for the Court of Appeals for the Fifth Circuit. So tomorrow, 5:15. Never mind. End of the week. So that gives me more time. Because I'm gonna have to look up the case law for Wednesday. But we have a deadline on May 15th for him to file his appellate brief for that dismissal on jurisdiction. So I guess let's go to the 47.1 thing. That didn't take as much time as I thought. It's just half an hour. So
somebody asked, let me see if I can find it. Okay, Prickly Pear asked, worst case scenario for Blake Lively happens and she gets pulled into Texas, loses, and keeps appealing up to SCOTUS. Do you think Alito may try to push it up to the Supremes to kill 47.1 because of unconstitutionality? I don't think the question of a fee shifting, this is my opinion.
Yeah.
Okay. I don't think the question of a fee shifting statute makes it that far.
Yeah.
And Babcock, so Jed Wallace responds to Blake Lively's fee motion, and Babcock makes it really clear this is a procedural statute that you cannot apply in federal courts, which gets a little tricky. We're talking about choice of law again, right? So we've talked about which state law applies, right? We've talked about that a lot. Then you have like, do state laws or federal laws apply in federal court? And procedural stuff typically stays with the venue, right? So if it's procedural and it's state law, it would stay with that state. Broad strokes here. And otherwise, the federal court would apply its own federal procedural rules.
Right.
So Babcock is saying this is not the kind of statute that courts would apply. And so there's a lot of case law from the Supreme Court already about that. I don't think that goes back up to the Supreme Court because the question is it substantive law or is it procedural law? Had she kept open her appeal for 47.1 in the Lively Wayfair case, then I could see it making its way up to the circuit courts. But again, we still have a choice of law issue that I think bars it from getting all the way to the Supreme Court. But I don't know.
I mean, I've been optimistic about this, maybe a little too much in the past, but I also do think she gives up at some point. I think she takes it to the media rather than continues to do this. Remind me to charge clients $800,000 for a motion to dismiss when I open a law firm. Absolutely. As your future paralegal, even without a paralegal degree, I'm going to charge everyone, I'd say $500 an hour to be a paralegal. Yeah, $800,000 for a motion to dismiss.
That's bananas. I was really racking my brain at like, okay, what's her, best case scenario for the 47.1 motion in the Lively Wayfair case. And I made a video. So LGA, like, see if I'm being too conservative. I just don't see how you justify more than 10 hours for a motion to dismiss and then a couple hours for a reply. Am I way off base on that? That's what Arizona courts would do probably in a case here. I mean, unless the issues are so complex, but we don't really have complexity of issues enough to justify that much time.
And I assume she's also asking for, I guess, let me actually pull up this, the thing she was asking. So I want to go through some of the questions. Is the 47.1 fee request enough to tie her to Texas? This is a really interesting question. I don't think the fee request in and of itself is, but what if they say we can do an evidentiary hearing, but then you would be conceding the jurisdiction?
Right.
Because I can't do an evidentiary hearing if you're saying the Texas court doesn't have jurisdiction.
Prickly Pear, excellent point. She did have 19 lawyers for the last hearing.
Yeah.
But also, reasonableness would look at how many lawyers does it actually take to do this? And as much as we joke around that it takes 19 lawyers to argue about how it should be done and one paralegal to actually do it, that doesn't make it reasonable.
Right. I don't know.
There's just no world where you say this really pretty simple motion to dismiss. I find there are a couple of like more complex issues. Nothing super out of the realm of ordinary. There's plenty of case law on all the issues that she presents. I don't know. I just don't know how you land that plane, but
our lawyers type very slowly, so it's actually 87 hours.
Right.
So Tanner has a good question. How can Jed drag Lively to Texas? Wasn't Jed dismissed because of the same jurisdiction issue? Yes. So essentially, the Texas court said, at least for now, you can't sue her in Texas. You have to go to New York to sue her. And then the New York court said, you can't sue him in New York. You have to go to Texas to sue him. I think maybe they could both go to California. They might.
Which Jed does not want to do.
Right.
I mean, he lives in Texas for a reason.
Yeah. So I think, doesn't her submitting this mean his appeal has a better chance of going forward since she's now trying to apply Texas law? Maybe. Nobody knows. Anybody, like, I think not actually Golden said this, but anybody who's telling you how 47.1 works or anything that happens from it has no idea, because it's fun. That's why I'm going to try to explain it on Wednesday, because I don't have a law degree. And so if I get it wrong, it's not malpractice.
And I will always defer to Little Girl Attorney on this because she actually practices in California and can give us an idea of how the fee shifting statutes work there generally, right? So always defer to her and her expertise.
Okay, so let's see. So if we go to her, I don't have it pulled up. That's why. Okay, so this is Blake Lively's 47.1 motion. What I would say is with the 800,000, I kind of suspect she's including the fees against Jed in the New York case.
That makes sense.
That's what I kind of assumed, and it didn't really occur to me that she might not be doing that until you guys were talking about how expensive it is. She might be including her attorney's fees with the New York case, which, doesn't make any fucking sense, but what in this case does. So, yeah. I mean, because she is talking about the New York complaint in here. Let me look at the damages. Let's see. 47.1. I mean, I will say the biggest problem I have with 47.1 in this case is that she is not accusing him of harassment. She's accusing him of aiding and abetting retaliation, which isn't a privileged statement under 47.1.
Babcock does a really good job knocking all that down. You guys, I said it privately offline. I'll say it here. I think he's the best lawyer to appear in any of these proceedings. I love his writing. I love how snappy he is. And I think he's really clear. He's allowed to be snappy because he's very, very clear in how he writes.
Yes. And I mean, I pointed this out to Brett too, that I did think it was funny how when he was filing in the New York court, he mentioned being a 5th generation Brooklynite. And then when he's filing in Texas, he's like, I'm from Texas. I love Texas. For $800K, it's a lot of cut and paste from the New York Step 47.1 briefs, right? It's just, it's the same argument with Wallace's name substituted for Baldoni. And it's like, this doesn't make any sense, because she's suing him for aiding and abetting retaliation. So, and then Jose says, isn't there a nexus to Texas? Isn't there a nexus to Texas when she did Book Bonanza? And yeah, I think that's going to come up in the appellate brief, as well as that whole thing she had at the hotel.
That's his argument, right?
Yeah.
Is that's what he used to say, no, there is jurisdiction.
Yeah.
Because she was here when a lot of these issues arose.
Right. Some of this was done in Texas, and she has that link. Now, and for jurisdiction, remember, you just have to, it's not necessarily about the case. It's about having subjected yourself in some way to the laws of a particular place. So if you have a house there, if you have a company there, if you do business there, basically the question is, has the person reasonably agreed to subject themselves to the law in another state? So like for me, I'm in Colorado. I've never been to Florida. Can I be held responsible for something under Florida law if I've never been to Florida and I've not done anything that's kind of put me under jurisdiction in Florida?
And there's a limit on that too. I mean, while she was doing Book Bonanza in Texas, I don't know that means that just for anything she ever does ever, that she's agreed to Texas jurisdiction.
Exactly.
Right? Like,
right.
And I think he's going to struggle to say the things that happened at Book Bonanza then mean that this thing that she did with the New York Times that didn't happen in Texas now by Texas law. There's arguments there, but I don't know.
I don't know how Texas thinks of that. Yeah, that might be something I'll do on Wednesday. I'll try to look on Wednesday to see like the jurisdiction argument. Also, thank you for the super chat, Jose. And then Lauren, no thank you for the super chat. Although I do think it's funny that you gave Britt $1.99. But look at this, Britt. She gave you $1.99. She gave me $2.
Blasphemy.
I just want to point that out. I'm not saying she likes me more. I'm just,
she does.
But I'm just saying.
You're the funnier one. I'm just ha-haing in the corner.
She likes me 0.5% more than you, as far as we can tell. A scintilla.
I will be saving you a seat at the Laura Owens trial. So now what?
There you go. I would also take be Britt's date to the Laura Owens trial. Okay, so going back to this. Okay, let me look for the fees, because now I didn't even think of that with the fees.
Also, what a funny way to think of it. Do you want to go on a date? Do you want to I don't know, go watch a trial?
Yeah. I mean, I kind of have done that. Like, I've gone to see a trial just to go to see a trial.
I've had many people where I'm like, hey, are you here as a witness? And they're like, no, I just watch trials. I'm like,
Like,
dope.
I would be that like retired person who's like, this is what I'm gonna
100%.
do, you know.
Just hang out at the courthouse.
You know, and then you can be like, I know what's going on. The one time I did that, it was a murder trial. And it wasn't full. And I'm not from a place where that like is normal, you know.
Huh.
Not that murder is normal, God. But like, you know what I mean.
Colorado, everybody.
Colorado. Yeah, there's a reason we're in the 10th circuit.
I have a friend from law school that graduated the either the semester or the year after me, and he is one of the most talented litigators I've ever met. And I keep telling him, like, let me know when you have a trial because I want to go watch.
I want to see you.
I want to see you in action, my friend.
Okay, so, you know, I do think it's including the New York thing because she's saying estimates the amount of attorney's fees sought in connection with the dismissal motion and related filings. I don't know.
She didn't attach a fee statement to this, right?
No.
I didn't think she did, but
when does she ever approve herself? Let's see. Yeah, I don't know. Leslie Sloan spent like $1 million on her lawyer, and that was also fairly straightforward.
I don't like. I can't. I feel like what I charge is way too much money per hour. And you could give me the like, oh, but you went to law school and the bar and it was so expensive. And like, oh, okay, I memorized a bunch of facts and answered B to everything. Like, I win, okay? I didn't answer B to everything, but like, I charged $3.25 an hour. And that to me is crazy.
Yeah.
So, see these big city lawyers
who are charging 10 times that.
Like $900 an hour. We had a case with New York Co-Counsel that charged $900 an hour, and we constantly were like,
I mean, I think
they're not doing anything.
Now you've got me thinking, because it came up in the New York Times case. So let me look for the fee motions. Cross motion. Here we go. In-house. So this is the New York Times attorneys. And these are in-house counsel. That's just how many hours. Fees affirmation. Oh, wait, there's invoices. All right. So for the month of April, okay, so maybe that hours thing is actually going to matter.
Invoice total, but they don't give you how much.
Yeah.
That would not be a proper fee affidavit where I'm from.
Let's see. And I don't know, is that just Davis Wright? Because if I'm going here, well, they do put the hours here.
Oh, got it.
So 361.5 hours is what we're saying.
I mean, they probably charge different amounts, but we could average it out.
Yeah. And then what's our total?
Everyone's like, how did we get into this math problem?
All right. 153. 4.7 divided. Okay, so this is where I'm getting this 153 number. There's other stuff, but I think that's the paralegal. So I'm going to go this number because that's the majority of it. Okay. And then I'm going to just so you guys understand how I'm doing my math. And then 361.5. That's an average of $423 an hour.
That's not bad. I mean, some of that is probably paralegal time.
Yeah, and that's...
And I get it. Did you guys discuss how the communication isn't even privileged? We didn't really get into that. We kind of intimated how Babcock gets there, but we sort of skirted over that the privilege under 47.1 is a communication about sexual harassment.
Right. And this is and she's accusing him of aiding and abetting retaliation, which isn't part of that. So let's just quickly go over what Wallace responded, what Babcock responded. So, all right, unbelievably, Lively is once again back for relief from a Texas court. This time, she twists the court's determination that it lacked personal jurisdiction over the claims against her as a decision on the merits of one of her affirmative defenses. We are so used to this. So she says she wants $800,000 court costs under a wishful reading of a strictly procedural California statute that does not apply in federal court, but even if it did, would not give her the substantive relief she wants. I do want to point out how this functions as an argument that Lyman could also use. This is, I don't know if he's going to see it, but it is kind of something that, he could
And
use.
that's where I was talking about, he drives home more clearly the procedural element of this, but, he's saying this is procedural for a reason, right? Because a federal court sitting in diversity jurisdiction is not going to apply a state procedural statute.
Yeah.
And of course, her lawyers are probably going to come back and say, no, this is substantive, which,
we'll see. Okay, so Lively's request to make California procedural law apply here is part of an ambitious plan to have plaintiffs pay for her lawsuit. This just reminds me, every time I see something like this, I think of Danny saying that Lively is using the docket as her GoFundMe. And just, I laugh every time. So prompted by her publication to the national media that the plaintiffs harassed and retaliated against her. And, okay, so to get her to her desired result, Lively works backwards from the answer she wants, performing a surface level conflict of law analysis that ignores where the injuries to plaintiffs occurred in Texas and the interests of her home state in New York before concluding that California law applies. Lively's reason is as obvious as it is self-serving. Neither Texas nor New York have the same procedural statutory scheme that would allow her to recover the hundreds of thousands of dollars she seeks for filing a motion to dismiss, which tells me he doesn't agree with the fee stuff either. But Lively is not a prevailing defendant. The court has not determined that the claims were meritless. They were not. Instead, the court told us that it didn't reach the merits of the defense, nor could it. At the pleading stage, a court is limited to making findings of fact related to jurisdictional matters on a motion to dismiss. So we start with the jurisdiction. If we pass that bar, we go to the legal pleading standard, and then we go to the facts, right?
Right.
Everyone
and he's saying
knows.
That's not prevailing.
Right.
Because they got to the threshold issue and said, this isn't the right court.
Yeah.
That's not prevailing because we can still bring these claims
in another
somewhere
court.
Else. Yeah.
Yeah. So there's nothing on the merits. I don't think there's any response to this. I can't imagine what the response is going to be. Are they saying that if it gets dismissed for jurisdiction, it means you won your case? That would be a fascinating precedent.
You're saying Lively's lawyers?
Yeah, Lively's lawyers.
Yeah.
Sorry. Yeah. So, all right. So basically,
yes.
Yeah, that's the only argument. Yeah. So, what he's saying is they're asking the court to disregard the plaintiff's well-pleaded allegations of malice that defeat that privilege, right? And the court didn't say if they were well-pleaded or not. They didn't get to that. They didn't get that far. So if they refiled their claims in another court, would that go against the settlement? I have no reason to think Wallace is party to any of the settlement stuff. So
Wallace is not a signatory because he's no longer a defendant in that case.
And the Wayfair parties, as they've been called, like in the litigation, don't include Wallace. They only include the people that she actually sued the first time that she filed her lawsuit. The SCOTUS case makes me crave bok choy. I'm excited about that case. So let's see. Okay. So the great irony of Lively's motion is that it forces plaintiffs to spend time and resources responding to point after point made in her motion, despite the motion's substantial flaws from end to end. In the process, Lively turns the true goal of Section 41, a foreign statute with noble aims, on its head while refusing to acknowledge the serious consequences of her defamatory conduct. I hope Babcock gets to go on TV at some point and talk about this.
You just know he's a character.
I mean, I don't know if
he has that big old hat too, that Sam Elliott hat.
Yeah, and his I Heart NY shirt. We're both at the same time.
I would love if he has like a New York accent when he goes to New York, and then has a Texan accent in Texas court.
And I did a video on this, but this is actually very true with attorneys, that like a local defendant and a local attorney do much better with a jury. Having the local accent, being from that area, a local plaintiff, I should say a local plaintiff. The studies say that local defendants don't matter, but local plaintiffs matter.
I mean, that's so reptilian too, right? Like
Yeah.
they want to stand up for people within their community, and they want
Right.
to see people as like in the in group.
Yeah, they want, so Lively would have a better shot, I think, in a New York jury than a California jury, or definitely a Texas jury. She's going to wear those fuck ass red shoes, I promise.
She's going to need for her.
She is going to need a whole jury consultant for a Texas courtroom. She's going to wear like 4 bolo ties.
She would hire a California jury consultant, and good luck to her.
Oh my God, Longhorn buckle, you're right. She'll come in with cowboy boots with red on the bottom.
Yeah.
I'm barely kidding, right? She changes her Instagram profile picture to her with a cow. 4 pairs of pants, right? 4 pairs of assless chaps.
All Wranglers. And 1 pair of Carhartts.
Oh my God, the Carhartt. I forgot about the Carhartt. All right. So basically we go through the procedural history. I will go through this in more detail. I'm going to read this out loud on Wednesday, so I kind of don't want to read it now, but They're talking about how Texas has the state is where they filed the case. The tortious conduct. So this is where, they're talking about like she's from New York. They're, although they are saying like plaintiffs also complain about Lively's actions in Austin, Texas and Waco, Texas. So we'll see. I think that's what this appeal is going to be. This hotel thing might wind up mattering a lot.
Remind me what happened at the hotel.
So I was watching this unfold live. Like, this was crazy. So this woman is at this hotel, and I guess Blake Lively was there with, I think, Joanna Gaines. And this woman is like videoing Lively and Gaines in the hotel lobby.
Okay,
right?
that was where, and she like flips out.
Yeah, so her security got mad or whatever. So the woman and I think her mom left the hotel, got in a car, but then people were kind of following them like into the parking lot and like chasing them to try to get them to delete the footage. And I kind of wondered if the jurisdiction thing was part of it.
I mean, I still am not sure how that confers jurisdiction for Jed's claims.
Is she opening a business in Texas? Or maybe she thought she was gonna. I don't know. If she has a business in Texas, I think that could do it.
I think the principal place of business would have to be in Texas, right? So, or like the business stuff gets like kind of complicated in itself. Like you would look at the principal place of business. Now, if he was saying I used her hair product and I went bald and all my hair was singed off, then he would say, because she's then availing herself through business activity in Texas.
And Chip and Joanna live in Waco. So maybe if they started a business, it's in Waco.
I always think of Garth Brooks's other personality, because wasn't it like Chris Gaines?
Oh, yeah.
So I'm always like, it's not Garth Brooks and Trisha Yearwood.
Yeah, I mean, I don't know. I'm looking at that. Yeah, Magnolia Market is their company, and that's in Waco.
Chip and Joanna Gaines.
Yeah, Chip and Joanna Gaines. So maybe she was thinking of doing something with them. I guess we'll find out. Maybe he knows something.
Yeah. I mean, if it was related to his claims against her, then he has something.
Let's see. I'm gonna pull up this article. If it lets me, it may not let me. It's thinking.
If she was doing business with Joanna Gaines, it could have been a Target business deal. Yeah, but that, I don't know. I don't know what a Texas court does, to be honest. They're different and special down there in Texas. Just so, in case I really haven't driven that home.
They're different, yeah. To say the least, they're different. And that's something to consider, guys, if you're like listening to all this. Like it might be like, oh, okay, well, this is going to play against her. But should it? right? You should also think about that too. Like, imagine it's someone you have maybe a little more sympathy for. So anyway, so this lady was so she was followed to her car by an upset Lively, phone camera in hand, as she filmed Cooper's license plate and circled the car.
Right? Oh, I do remember this.
This is what happened. So that was the Waco incident, and I think we'll probably hear more about that when this appellate brief. I wonder if he's going to use it to.
I think his best bet is that she was. I don't know. I don't know. I don't find it very persuasive. Sorry, Jed, if you're watching.
Does she?
Sorry to be the wet blanket.
I'm just thinking about Book Bonanza. Now that I'm thinking about this, so he could put something in the appellate brief from the docket in Wayfair or Lively v. Wayfair, right? Could he have the court take judicial notice of something from that other case, or is it?
Yes.
Okay.
So everything that has been filed, all 1,400 documents or whatever, are public record, and the court can take judicial notice of anything that's public record. So they can mine through all of those and determine what happened at Book Bonanza was actually really central to this case, because it's central to her allegations of retaliation and smear campaign.
And I know what they're going to use. I already have an idea of what I think they're going to use. Because weren't they at Book Bonanza when she was kind of saying, like, I'm like, there was some sort of thing that Alex Sachs was at, I thought. And I thought it was in Texas.
A lot of the issues culminate at Book Bonanza. So communications with Colleen Hoover, where Colleen was like, they were trying to get me against you. I think that happened in Texas, where she finds out about the retaliation or whatever in Waco, in Texas.
Yeah. And
I don't know that it's the worst argument in the world. I just don't find it particularly persuasive. I don't know. Here's my issue, guys. I don't want people to have minimal contacts with a state and then that state to say, we're going to have this big, wide open jurisdictional issue, we're able to confer jurisdiction on you for a lot of things that aren't related to this like small visit you had.
Right.
But the Book Bonanza happened in Waco, and it was a huge part of a lot of her discoveries, or so she claims. A lot of her allegations center around Waco, is what I'm trying to say, and I'm too tired to say.
Yeah, so Alex is talking about, this is at Book Bonanza. I don't know if she says this, but she says, Blake, Brandon, and Isabella are going to celebrate. Blake is thrilled. So they're talking about, Blake is teaching him what to do. But then this is the big thing. So Alex Sachs is texting from Book Bonanza, and she's saying dinner was lovely, a lot of shit talking. They all hate him. And they're all kind of getting together and talking shit about him. And I guess this was in Texas. There's a possibility that he's going to bring up some of this.
Sure. I mean, you take anything you can.
Yeah.
And then she stopped in Texas at a road stop one time and got into an accident. Like you're really like, in the same way she did with California, where she was like, well, they made a phone call from California one time. Their shirts were made in California. They made a California avocado on their toast while they were doing this retaliation. Like, you drive home anything you can.
We are all Californian, as we know.
Not.
It's too late. You've been declared California. You've been assigned Californian by Blake Lively.
I cannot afford California. I would love to live in Southern California. It's not in my price range.
What's the burden of proof that has to be proved for Jed to have the appeal in Texas? I don't really know. He's going to bring in his stuff, so that'll happen on the 15th. If they turn down his appeal, can he file another lawsuit against Lively in New York? Yes. I joined the Lively. So yes, he can sue her in New York. So you can always sue where the person lives, because if they live there, they've definitely availed themselves of the laws of that jurisdiction. So wherever you live, you can always be sued. You're never truly safe. Okay. So can two people who live in different states not sue each other? Then they can. They just have to, you sometimes have to go to where the person is, because that's where you have to argue. Book Bonanza was in Dallas. Okay.
Okay. So
let me go back.
I had to look this up in my notes. It is a de novo standard, which means of new, I think. This is in my notes from a million years ago.
Mm-hmm.
Because it's a question of law, right? So the dismissal was a question of law. Is there jurisdiction here? That's a strictly legal question. So the court will look at it of new,
okay,
which is a de novo standard. And so I do so little appellate work that I can never remember the different standards. But that's, if not actually Golden is still here, correct me if I'm wrong. Or Little Girl Attorney.
Yeah, so we should see. I'm kind of excited for this now, because it might be another chance for him to get his version of events out there. And the timing couldn't be worse for Blake if he does decide to do that. Okay. The parties do not have a relationship. Wallace never met Lively. He still has never harassed her. It was never on the set of the film, blah, blah, blah. Okay. So plaintiff's complaint is not about the filing of the CRD complaint, which again, I think goes back to that Landry case. Here we go, Britt. Ask MJ. She should know.
Who?
Mary Jane? Is her name Mary Jane? I guess
I used to love Mary Jane in college. Not so much now. I'm too old.
Right.
Wasn't Book Bonanza where she showed her cut of the movie? Yeah. Yeah, and he did make all these arguments in his response to her motion to dismiss. Or maybe there was a motion for reconsideration. I remember at one point I read, he does really drive home this and then this happened at Book Bonanza, and then this happened. And that's the thing too, guys, when you appeal. Yes, okay. Thank you. Not actually Golden with the assist. Yeah, the court is going to look at the record of new. So he can't make new arguments. So he's limited to what he's made. But he has made these arguments that, and then she walked out and saw the fresh air at Waco, Texas, and said,
right,
Jed, screamed it at the skies or whatever.
But he did get the Book Bonanza thing in there.
Mm-hmm.
And so I mean, there's already he's got his hooks in.
Yeah.
So even if California law applied, she cannot obtain attorney's fees and costs because of the procedural posture she created. Lively does not qualify for fee shifting because there's been no determination that her communications were privileged. For what it's worth, Lyman has not determined if the communications were privileged in the New York case either. Right. So we're kind of here in both cases.
And the privilege, do you have 47.1?
No, but I can get it.
I have it.
Okay. So here it is.
So it's privileged under section 47, right? But it has to be a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination. And then it's privileged under 47, which is California Code 47. So a privileged publication or broadcast is one made in the proper discharge of an official duty. Little Girl Attorney is probably screaming at her computer right now. In a legislative proceeding, judicial proceeding, or any other official proceeding authorized by law, in the initiation or course of any other proceeding authorized by law. So that's kind of what we were talking about with, what is the case again?
Landry. Yeah, the Landry case.
Right? It's a broadcast that's made in the proper discharge of an official duty in any legislative proceeding, judicial proceeding, or any other official proceeding authorized by law, right? So we're looking at whether or not only attaches to comms regarding sexual harassment. Exactly.
And so I just want to point out too, because I do think this is the stronger, this is just the easier argument. In this, they say sexual assault, sexual harassment, discrimination, aiding and abetting, inciting, compelling, or coercing. Actually, now I'm reading this, now I don't know, right? Aiding, abetting, inciting, compelling, or coercing an act of workplace harassment or discrimination, or an act of retaliation against a person for reporting or opposing workplace harassment. So this is so poorly written. Do you read this as including aiding and abetting retaliation?
LGA. I think, but what Babcock is saying is that it's not privileged because he didn't have any sort of contract with Lively. He's never been in the same room as Lively. Like, he couldn't have done these things because of like the tenuous relationship that he has with Lively.
Well, but if you look here, okay, sorry, not to argue Lively's case, but I'm going to do it. It does say in this subsection 3, an act of workplace. So the communication is including but not limited to any of the following, right? And one of these things is aiding, abetting, inciting, compelling, or coercing. And so if I look at the causes of action, this is what she sued him for. So I'll just pull this up just to remind everyone. She's suing him for aiding and abetting harassment in violation of FEHA, right?
Is this under 47? Is that what you're looking at?
Oh, let me see.
Because 47.1 says it's privileged, but it has to be. So you would do the analysis under 47 is the way I read 47.1. I mean, obviously no one knows. And then it's privileged under section 47. And this, guys, is why one, I say defer to LGA because she's much more familiar with these statutes. And two, like, to not actually Golden's point earlier that we talked about, this is untested waters, uncharted waters, right? So there's no court case saying, here's how we're going to go through this. Like, here are the steps.
Right. There's nothing to do in analysis. But I mean, yeah, like, I guess you could argue here, this part of the statute does appear like it says aiding and abetting and maybe an act of retaliation. And she did sue for aiding and abetting. Does that mean the litigation was sincerely contemplated? I don't know. I don't know.
Or an act of retaliation against a person by the owner. That's housing.
No, it says workplace.
Oh, sorry. I was reading 4.
Yeah.
Do you see how close I have to get? Because I left my glasses at work.
So an act of workplace harassment or discrimination. 12940.
Aiding, abetting, inciting, compelling, or coercing. I just don't know how you get to aiding and abetting workplace harassment. Because it's not, or an act of retaliation. I hate the way this is written.
I know, right?
Okay,
right?
Please contact somebody and tell them that I personally dislike this.
But I mean, okay, now that I'm looking at this, it's like she does say aiding and abetting, and she did eventually file but she didn't add him to the lawsuit until this is why she didn't add him to the lawsuit until after he sued for defamation. So at the time he sued for defamation, there was no litigation. There we go.
So her lawsuit was retaliatory. No, I'm just kidding.
But that's what I mean. There's the argument, right? She didn't have a lawsuit for aiding and abetting against him at the time the defamation claim was filed.
Right.
Okay. Yeah, there we go.
Right, if you were old, I am ancient. I don't sleep well, so I feel 900 years old most days. That's all right.
You're still good at 900 years old, though.
You know, I can run like a mile.
I mean, that's more than a lot of people.
And I have a broken nose, so, you know. Mouth breathing while I'm doing it.
So's Rosie. It's fine. You guys are twins.
Twins.
All right, so let's see. Okay, so the court did not decide the merits of Lively's privilege defense. I do like that he bold stuff because then you can just read the highlights. The court did not and cannot decide the merits of Lively's privilege defense when it decided her motion to dismiss for lack of personal jurisdiction. Plaintiff's allegations that Lively acted with malice defeat her conclusion that her communications were privileged. And that just keeps going back to the same thing, right? What is the malice part? The malice part is, I think that's the thing. They're alleging malice. We have to have a finding of no malice. So doesn't this have to be like a jury issue? I don't know.
The two chat thing gets me confused sometimes.
I think because some people are in your chat and some people are in mine.
Heard. Got it. Okay.
Yeah.
Yes. Explain. I felt like a Dalek.
So yeah, so some people, they can't see each other's comments. We can see all the comments.
Got it.
But a lot of the comments like that you're seeing are not, like it's different.
Heard.
Yeah. Okay, so Lively alleges a communication is privilege and played to sufficiently allege malice to defeat the privilege. The motion failed. There we go. I think this is the strongest argument. I mean, she didn't sincerely contemplate litigation because she didn't file litigation.
Right.
I think they are in Britt's chat. I think they are. Yeah, they are in Britt's. Oh, no, they're not. Little girl attorney's in my chat.
Yeah.
Okay. Lively is not a prevailing defendant, like you said. Prevailing party, it means that there must be some sort of enduring judicial relief that constitutes a material alteration of the legal relationship of the parties, right? So jurisdiction is saying, get it out of my face. It is not saying that anybody has a claim. It's just go somewhere else to go argue this.
Right.
I mean, Mama Panda says, you got to give Blake props. She brought up a lot of flaws in the legal system. I feel like this entire case is amazing for like learning the system. Because so many
it's presented so many things that I haven't even, some of this stuff I haven't even thought about since law school.
Yeah, we're all learning. Why did she even forget Jed? I'm going to tangent because I'm going to show you why she didn't sue Jed. And this still pisses me off.
In her initial complaint?
Yeah. Oh. And the answer is, I think she was trying to turn him.
Oh. That was a terrible way to do it.
I know. Okay.
And given the clientele that Jed works with, I would imagine he wanted to maintain anonymity for the rest of his life. I don't know where I am. You're with us.
Let's see. Rule 202, where is it?
Come with me.
Where's the Rule 202 motion, Jed?
Mama Panda, I am daily impressed with how much people caught on, like, followed along and understood, like, this is complex stuff. Not Actually Golden was talking about how people were doing like high level constitutional analysis. I'm just constantly blown away, like, and I don't think you need to go to school. I don't think you need a degree to really understand this, but one, I'm blown away that people are even interested, and two, that people did, follow along the way they did. It's been really cool. I mean, the crim law girlies in my Civ Pro classes did not catch on to this stuff and did not do well on this stuff on the bar exam. So there you go. You're smarter than some criminal law attorneys I know.
It's a lot. I mean,
it's
a lot. Okay, I just had to go buy this motion, and so I'm hoping this is the motion. No!
I hate when I do that.
It's not the right one. Okay, so this is the non-suit without prejudice. It's not the right thing.
Americans still read and have reading comprehension. I truly believe there are many of us. We just aren't online. We're too busy reading. I mean, I'm online.
I mean, I don't read. I say that I don't read, and then I read lawsuits all day.
You read more than many people.
Um,
Are you saying I have a better legal understanding than Kim Kardashian? I can't speak to Kim's legal understanding. I don't know how she scored in her various sections, but the answer is it depends, but likely yes.
I mean, I think it's got to be insanely difficult. I don't know that I could. I mean, I wonder if I could do the baby bar.
I bet you could. But you would also apply yourself. If you were going to spend the money, you would apply yourself.
That's true. That's
to
true.
her, the money is nothing.
Yeah, that's true. So it's just kind of
which is the unfortunate part is I'm like, some of the issues she stands for, I'm like, I would love to have you in the profession if this is what you're going to fight for. The thing is, you don't need a law degree to be a celebrity face for overturning wrongful convictions. Anyway, Omar is the tilted lawyer. How did Omar come up? We love Omar.
The tilted lawyer is Omar. Let's see. Omar, yes. And Omar does a lot of the stuff with court of random opinion. I can't find this Rule 202 motion. I'm just going to try docket updates, and then if I can't, I'm going to give up, but I will try to find that. Basically, what happened is Lively filed a Rule 202 motion in Texas, which is a pretrial type of motion that says, hey, Texas, I think I'm going to file a lawsuit against this person, but I need to do some discovery first. So it's a request for pre-litigation discovery. So within weeks of saying she had voluminous evidence, she was filing in the Texas court saying, I need discovery. Let's see. Yeah, I don't see it. I will try to find that because I think I don't even know petition Texas.
And that discovery didn't go through, and then she just amended anyway. Am I remembering
correct?
That correctly?
Yeah, she withdrew it. That was the thing I just bought, was she withdrew it without doing anything. So basically, Rule 202. So this is before a lawsuit or to investigate something. So a person can ask for a pretrial deposition or some written questions or a declaration to get their testimony to investigate a potential claim or suit.
Which is what people were guessing happened in the New York Times lawsuit, because they were like, how did she get all this information from the Wayfair party's publicist? Oh, it must have been a pre-suit motion like this, but no one could find it because it didn't happen.
We just abused a subpoena. And also, so it wasn't her first lawsuit after Van Shim in Texas against Walls. It's actually this. It's a Rule 202 petition. So it's not a lawsuit. It's just a pre-trial thing because we're saying, I'm anticipating a lawsuit. I might have a claim. But the thing is, if she didn't have a prima facie case, that's why she would need this, right? If she had the voluminous evidence that he was involved, she wouldn't need this. And that's kind of, so that's just it. So she wanted this pre-litigation.
So how does this get you to the hypothesis that she was trying to flip Jed? I missed a step there.
I think the logic is she wasn't sure what his role was here. And I think not actually Golden has brought this up, but to go back to like the original thing, I think that this precursor thing that was filed in the New York Times article, I think this is a threat. I think that this was not intended to actually be filed right away. I think that this was a threat of where this could go.
Back down, give me everything I want, or here's what I'm going to do.
Here's where I'm going to bring you in.
And they said, hold my
kombucha.
Yeah, I was going to say
Betty Buzz
or something.
Holds my Betty Buzz. And I think that this could have been an intimidation tactic. And then, she didn't go after him. And part of the reason I think she didn't go after him is because he wasn't part of the affirmative lawsuit for defamation, right? In the New York court. He's not a Wayfair party. So he's not one of the plaintiffs in Wayfair v. Lively. So I think maybe she thought, well, let me go over here and see what I can do with you, because you've already kind of separated yourself from everybody a little bit. Wouldn't Jed be in breach of contract if he's flipped? I mean,
Depending on
what he did, right?
Yeah.
Yeah.
And flipping doesn't necessarily mean now he's like
Team Lively, yeah.
doing whatever he does in the media for Lively. It would just mean that he would favorably testify for her, probably.
Right.
So, hey, I won't sue you.
Exactly. I won't sue you if you kind of tell me what you did exactly.
Right.
And
I'll leave you out of this. But she didn't leave him out of it. And going to the New York Times, which is a publication of record, it's a huge publication, and dropping someone's name and their business isn't exactly a way to curry favor.
Right. She doesn't know that, though. Like, she doesn't know how to do this. I
don't know. She strikes me as somebody who's very successfully manipulative.
I think she's very manipulative. I don't know if I'd say she's successful. I think she misreads situations a lot. I think people are tiptoeing around her and she doesn't read it. I think she lies to people and she assumes they're telling the truth to her, even though there's not really a reason to think that. She doesn't seem good at predicting other people's actions.
She's certainly not good at reading other people, reading the room. That's fair.
Yeah. I think manipulation is about really understanding what they're going to do next, but you got to think 10 steps ahead. And I don't think she thinks that far ahead. Let's see. So, okay. Prevailing defendant. Okay. So she's saying Lively claims that because section 47.1 is similar to anti-SLAPP laws, blah, blah, blah. This court should just import the anti-SLAPP rules, which I think is a funny argument because, again, that doesn't work in federal court. And that's what they're saying. So there's a bunch of arguments. I would recommend reading this, and I'll go over it in depth on Wednesday.
It's only 22 pages. It's a great read. Babcock's writing is so easy to read.
Yeah.
He makes it very, very clear. Again, he's kind of snappy and fun. Throws little pot shots.
So the conclusion, for all her protests about litigating in Texas, Lively just can't seem to quit us. Her latest Mess with Texas finds no support in choice of law principles, Fifth Circuit law about how facts are resolved or not in the procedural posture she created, nor even in the plain text of the California statute she invokes for relief. Though we can't blame her for choosing Texas once again, it doesn't take a crystal ball to see the motion should be denied.
And
that's an Ella Langley reference, choosing Texas, just so you know.
The can't seem to quit us is so Brokeback Mountain coded that I'm like, okay, Babcock.
This filing is in the wrong court. They should have filed in California. It's almost like they don't want to win it. It's almost like the client is emailing them, Blake Ryan is emailing them and suggesting what to do things.
Yeah, I mean, that's the thing. Had she run to California, now there's a case in California where there likely is jurisdiction.
Right.
Hard to say whether there's jurisdiction over him, I guess, but
yeah.
This is a tough one because there is alleged wrongdoing here. She did run to the New York Times and say, I'm going to sue this man, and then did not sue him.
Right.
That could be defamation. There's a viable claim there. And where do you bring that? Because the answer can't be nowhere.
Right.
So where does that belong? And I think he's going to say it doesn't belong in California because California laws suck. I mean, because I've never been to California.
Right.
Because, no offense, LGA, that's just what a Texan would say. I'm just channeling my inner Texan.
And yeah, I mean,
I don't know. I mean, the answer has to be somewhere.
Let's see.
I don't see Jed going to New York just to sue. I don't either.
I don't think so.
And the law isn't as favorable in California or New York for him.
I don't think because litigation privilege, I think, could apply. Exactly. And I don't think it applies. I think Texas is his only shot. And that's, that litigation privilege. And just to have a recent appellate court decision overturning it and saying, no, we are not doing a bridge between the litigation and the press. You know, don't avail yourself if you don't have to. That's good for a t-shirt.
This is why I never leave Arizona.
I don't want to avail myself of any jurisdiction. There's probably Texans who say that. You know,
100%.
Yeah.
Oh, we have all sorts of sovereign citizens here.
I'm torn between. They're talking about their favorite writers in the case. I'm torn between Babcock and Fritz.
Very different styles. Both pretty clear writers. Babcock's a little more sharp in his insults and his little shots that he takes.
He has a stronger case, though, you know? Like, it's more direct with him because his facts are.
Also, isn't this filing submitting to personal jurisdiction? Yeah, so we asked that. Like, isn't she availing herself to this court now? And in doing so, isn't she
conceding jurisdiction?
Conceding jurisdiction, but...
And that's why filing this right now before his appellate brief is due is another stupid thing. Right. Because now he can bring this up in the appellate brief.
Right. In fact, since I filed my response and the court denied it, or the court granted her motion to dismiss based on jurisdiction, she's availed herself to the jurisdiction of the Texas court.
Yeah.
By trying to apply California laws in Texas.
Yeah. It seems odd. You did. A couple of people, I know you and Pam pointed it out. I think that, like, doesn't this mean that she's saying she has jurisdiction now? And I think, yeah. And that's what I mean. Turns out regular people can spot this, you know?
Yeah.
It starts to come together after a while. It does start to make sense where you're like, wait a second.
This is what the practice of law is, you guys. That's why we call it a practice. You start to understand the concepts, you start to apply them, you start to sit around with a group of other legal-minded people, and you start, okay, well, what about this? Okay, well, what about this? What do you guys think of this? I don't know. That doesn't persuade me. This is the most fun part about practicing law, is sitting around with people who understand the concepts and just discussing what we think the strongest arguments are.
Yeah.
The international law students. Y'all are funny.
Get your TikTok law degree. So yeah, I'm going to go through their this Wallace brief, since I've got more time now before their appellate brief or their appellate argument drops. I'll go through their case law and kind of see.
And join Sarah on Wednesday, because she's going to read that entire Babcock brief, and it's a juicy one.
I can't do the accent.
He's a funny guy.
How do I get a hat, a cowboy hat before Wednesday?
You didn't get a cowboy hat for Beyonce's Act 2? What's wrong with you?
Cowboy hat and an I Heart NY shirt.
Go ahead.
I
don't fully understand why she didn't only sue Wayfair parties, was suing Jen Tag in order to bring in docs, or why. Her why will forever baffle me.
I think it was to get them to turn on each other. I think she thought that the Jen Abel and Melissa Nathan would toss Wayfair under the bus. So I don't know. I think if that's the case, I think she severely underestimated how people react when challenged, right? Because her whole premise is the very nature of the thing you do can now be considered retaliatory behavior by it under, workplace principles. Yeah.
Words.
And I mean, Gloria says, she thought they would toss each other under the bus because that's the way she and her friend group behave. I mean, I've pointed this out before, but Jamie Heath and Justin Baldoni's emotional support billionaire said, no matter what happens, I'll still love you guys, even if we never make another film.
We have matching tattoos for life.
Right. And then Blake and Ryan's emotional support billionaire made a song saying a good thing I like my friends canceled, and then proceeded to keep their name out of her mouth for a year and a half.
Yeah.
You know, maybe they're friends, maybe they're not, but she hasn't publicly supported them. And I think Sarowitz is probably funding the whole lawsuit.
Right.
So Mama Panda said, wait, can Jen's business sue her? So RWA Communications is Jen's own company. And then Jones Works, we're still waiting to see if Jones has to indemnify her for the Lively stuff. I'm still waiting for that.
Or at least for the actions that were taken before Jen left Jones Works' employ.
Yeah. I always thought that's why Leslie Sloan called Melissa Nathan the day Stephanie Jones took Abel's phone to try and make her turn. I agree. Yeah. You know, prepare to get sued. And then think about whether or not you really want to lose your business defending these guys.
We're going to sue you unless you want to team up.
I mean, Zane says, I've been wondering if this is a targeted takedown of Tag. They're not unique yet presented as if they're the only ones among pure PR. The Jones case is going to be really, really interesting because I think the Jones and Nathan thing is the underlying conflict in this.
Oh, yeah.
And then this came up around it. And I'm curious. Danny and I have talked about this on the phone at length. And I still think that Jones went to Lively and lied. That's my theory. Obviously, I don't know anything. It's an allegation. I'm going to put up my little don't subpoena me thing. But I think that Jones may have gone to Lively and oversold what this lawsuit could have been. And Danny thinks that Lively took Jones went to her in good faith, and she took it and ran with it. So Danny's like, I think Jones is in the right here. And I'm like, so I mean, I'm excited either way because I'm curious, you know.
Yeah, I mean, bringing in Melissa Nathan seemed to have lit a fire under Stephanie Jones.
Yeah.
That seems like there's personal animus here more than Stephanie feeling like Blake was this, you know, little victim to crisis PR. It's like, well, that's a normal extension of your industry, it seems.
Yeah. Yeah, I mean, there's yeah, I don't know. The Jones thing is interesting.
Too many scissors in the stationery box. Stop. That's hilarious.
Let's see. What is the next Jones moment? So they have a status conference August 19th, which is going to come faster than y'all think. And we're still waiting on Jones's motion to dismiss. We have not heard back. She did file a motion to amend, so that kind of delayed things. But that motion to amend was not granted. So her second amended complaint is now the complaint that is like the operative complaint. So we're waiting for that motion to dismiss. Wayfair and Abel and Nathan and all them have answered her stuff, so that's ready to go to whatever the next stage is. So that could be a motion for summary judgment. I hope there's going to be a motion for summary judgment and another document drop, like the great unsealing, you know.
Mm-hmm.
Yeah.
Didn't Leslie say on a text, Stephanie Jones is full of shit, or am I crazy? You are not crazy. And I've actually wondered in passing, and I'm going to say it out loud now, if the subpoena had something to do with the fact that Leslie didn't trust her. So she was like, make her turn over everything. So let's get a subpoena and let's make her turn over everything. She's going to turn it over anyway. So let's just be sure. I mean, it's kind of a reach. There's no real other support for that, but yeah, it's always baffled me that Leslie was like, I don't believe a word that comes out of her mouth. Hey, let's go to the New York Times with all this information she gave us. Can you see what I'm working on? I am making a hummingbird.
So let's see. Sorry, I just got distracted because there's a motion to dismiss in the Smith v. Wayfair case. And I don't...
which is their other workplace discrimination case?
Yes. Okay. Yeah, that's the workplace discrimination case. I'm buying the filings right now. Sorry.
Who is Smith? Who
Celeste
are you?
Smith. Yeah, let's see.
A Ryan Reynolds plant who is claimed. No, I'm just kidding.
This is short, so I'm just gonna pull it up. We can always do another. I'll do like a video or something on it. Okay, so Wayfair Foundation. Celeste Smith filed a complaint against. Oh wait, it's not pulled up. Okay, the Wayfair Foundation filed a complaint against the defendant. Let's see. Plaintiff asserted 7 causes of action against the foundation: sex-based discrimination, race-based discrimination, retaliation, retaliatory harassment, violation of the Age Discrimination in Employment Act, violation of the ADA, discrimination of the Illinois Human Rights Act, retaliation under the Human Rights Act, and promissory estoppel and equitable estoppel. The foundation was a nonprofit organization that closed July 1st, 2025, when they were separated from employment. Plaintiff's complaint against the foundation's warrants dismissal in its entirety, as it is a paradigmatic example of a conclusory pleading that strings together nearly every conceivable employment-related claim without supplying the factual allegations required to state any of them. Plaintiff relies on vague, generalized allegations of speculation and recitations of legal elements. To begin, they are deficient as a matter of law because she does not allege sufficient facts to support that adverse employment action occurred because of her protected characteristics. Retaliatory harassment fails as a matter of law. She fails to allege that she suffered an adverse employment action. Age discrimination, ADEA claim, court fails because she alleges no facts suggesting that age was the but-for cause. It's very short, yeah. This is what a motion to dismiss, and actually I was going to say that to Mama Panda and Pam, the graduates of the International TikTok School of Law. This case is not normal. I want everyone to understand how not normal this is.
The Lively v.
The
Wayfair.
Lively case, yeah.
I mean, some of it was, right? I don't want to take that away. Like, some of the fights they had over discovery and okay, but the amount, some of the like 800,000 for a motion to dismiss, like stuff like that is.
That's normal, yeah. But I mean, I think the media side of things, all that is so different. Wayfair Foundation, and so that was the other motion to dismiss, which I think is a little bit more interesting too. 3 pages. Wayfair Pathways. Here's the causes of action. Pathways was not plaintiff's employer, and there are no facts alleged to support that it was. Plaintiff improperly relies on group pleadings, which now we're all experts in from the Wayfair case, the main case, by lumping together defendants without identifying that Pathways employed plaintiff or providing any factual basis for treating both these entities as the employer. Complaint against Pathways warrants dismissal in its entirety because plaintiff fails to allege that Pathways was her employer, and the allegations set forth in the complaint undermine that conclusion. She fails to allege exhaustion of administrative remedies. You guys now all know what that is because the CRD complaint or EEOC complaint, you've seen that. And then plaintiff fails to establish that promise, misrepresentation, or concealment of material fact was made to her by Pathways. And then please dismiss this. And then Steve Sarowitz has a motion to dismiss, which is the same thing, but it's basically there is no underlying individual liability because he's not, as a person, he is not the employer. And then she says, there's no allegation that Sarowitz made a complaint. So this is very straightforward. 2 pages and then 3 pages. This foundation is closed. So this case, there's very little filings. Wait, did that filing go? Is it blue? There we go. Okay. So she had filed an employment complaint against Wayfair Foundation and with a lot of employment allegations of age discrimination, gender discrimination, racial discrimination. I think it basically boils down to the foundation closed in 2025. Sarowitz testified in his deposition in the Lively case that it closed in part because of the attacks. He said there were anti-Semitic attacks and also, I think, the attack on his family. And that's part of the reason they closed the foundation. And what she is saying is they have started like another foundation, this Wayfair Pathways, or another organization of some similar kind, and they didn't rehire her. It seems to be You should read this, Britt.
Your beating is beautiful. Oh,
I don't know how to pronounce that, but
I don't either. But thank you so much. And this is my favorite way to shut off my brain, which my brain turns right back on somewhere between 2 and 4 in the morning every night. So fat load of good this does. But I love beating so much.
I like the peacocks of the prairies. I like that phrase and that
Yeah.
visual. So, the witching hour. That's what it is. It's the witching hour.
You know, my ancestors are calling me. Get up, light a candle. Hex somebody.
Right? It's 11 o'clock in the morning Irish time. You're sleeping in, genetically speaking.
That is true.
Um, so yes, yeah, she's saying that everyone went back to Wayfair after the foundation closed, but she wasn't hired, and it was because of discrimination stuff. I see, Zane. I started doing these diamond art paintings. I feel like I like them, but I can't do another craft. I just have a graveyard of things that I've abandoned, like entire hobbies that I've abandoned.
I have musical instruments sitting.
I'm looking at a harp right now. Yeah.
There's a piano right there. Do I know how to play it? No. Did I learn some chords? Sure. Is that all I did? I have a Fender ukulele in my closet. Like, what am I doing? So anyway, I should pick up those diamond paintings.
Yeah, and then you can start a whole new hobby, and then can Jed be reimbursed if this case is found frivolous? Probably not. Yeah, Katie, I'm still live. I wasn't lying. She sent me the link to those Wayfair things, and I said I bought them and I'm reading them on live, and she's like, "Oh, no, yeah, really, I'm still
It's
live."
only been an hour and 47 minutes.
No, I've never quite I've never played the harp. I just own a little harp, and then I was like, I'm gonna learn to play the harp, and then I never did.
You have the angelic hair for it.
It looks like I could play the harp, you know.
Yeah.
I'm on day 5 here.
Shout out, go ahead and just let us know in the comments if you are the type of person who picks up hobbies and then never pursues them realistically.
Right.
Life
Katie,
is true.
I can play Beethoven on piano, if you can believe it. I believe it.
I believe it.
Yeah.
But you're tall and you have tall people fingers, I would bet. Sounded weird, but like I have these little stubby hands, and literally every instrument is a nightmare to play.
See, no, I don't have that excuse.
Is Brit a Pisces or a Scorpio? Neither, but I have a Scorpio stellium.
Okay, so let's guess our astrological signs.
You missed the one water sign that I am. I'm a Cancer rising.
I'd have to, Capricorn. I think that's the one I decided I was.
I picked this one.
You should be allowed to do that. You should just be allowed to decide what your sign is. Why should the stars get to do it?
Libra through and through. I do have a Libra sun. You guys are, I feel called out.
Let's see.
Britt is a Virgo. Interesting.
I think I should just get to be a Capricorn because I want to be. I don't know if that says anything about my actual star sign. So if that helps, that I'm just demanding.
I mean, can I pick Aquarius?
I think you should be able to pick whatever you want.
Yeah.
Yeah. My sun sign and the moon sign are the same. And then I like the third one. See, yeah, there you go. Sarah's giving me Capricorn vibes. See? Yeah, that's it. Yeah. No, I'm a Leo. My sun sign is Leo, and my moon sign is Leo, and my rising sign is Capricorn. But I like this too, Gemini, because I can portray both sides. I like that. I don't know anything about the signs. All right. Is there anything else we have to say about Wallace right now?
I think that's it. I think I genuinely think the Texas court is going to laugh her out of court for trying to apply a fee shifting statute from California. I just don't see a Texas judge being like, sure, yeah, let's do that.
Let's see.
Federal judge, so not exactly like a Texas state court judge, but.
All right. I'm going to do an exit poll.
All right. So you're going to hit 1
in the chat.
Ryan is going to Taylor's wedding, if Blake is going to Taylor's wedding, if neither is going, or if both are going.
Yeah. I like you picking chaos.
Well, Taylor does like her proximity to movie stars because she wants to be one.
This is interesting.
Ooh, some people still think they're going to go. It'll be really interesting if they do go.
You know, there's a response in that Showgirl lawsuit, by the way. There's a motion to dismiss.
I figured there would be.
Yeah.
We'll have to go over that. Is it damages?
I haven't seen it yet. I haven't read it.
Got it.
One of the things I thought that was funny was they pointed out that there's no brand confusion because Taylor's fan base goes so through all of her stuff that they would know that it's not the same thing. Like they know they wouldn't
my fans couldn't possibly confuse me for you. That's not what we're saying, babe.
And then she gives the New York Times interview where she's like, I wish my fans would stop paternity testing my songs. I like this answer.
Honestly, that would be hilarious. She's like, sure, you can come. Here's your seat.
The funniest thing would be if she invited Baldoni.
On that note, my mom is calling and I have to go.
Is she really?
Mm-hmm.
Okay. All right. I'm going to stop the poll here then. We're saying neither of them are going. Let's see. So we'll see.
I'm going to log off. My mom's car broke down. I have to go get her. So everyone
have a good night.
Bye.
Bye. Let's see. All right. So I'm going to go live on Wednesday for the 47.1 stuff. I'll try to put together more 47.1 stuff. And join me on Wednesday if you have questions about it. I'm sure the attorneys will do a better job explaining it, but I'll try to go through it a little bit more just to help. All right. And yeah, we will see you all on Wednesday and have a good night. Bye.